In February, the Supreme Court of the United States told the president he could not impose tariffs the way he had been imposing them. The vote was 6 justices against 3. The ruling was obeyed the same day, the tariffs were switched off, and importers are owed refunds that could reach $170 billion. This Monday, the same kind of tariffs came back at 50%, double the rate the struck-down ones had reached. Nobody defied the court. Nobody ignored the ruling. The tariffs were issued under a different law, one that has been sitting on the shelf unused for 96 years. This is not really a story about tariffs, and it is not a story about Canada. It is a story about what happens when a country hands out pieces of its own power over 90 years and forgets to give any of them an expiry date. Here is what happened. On Monday, the 20th of July, the president signed 3 proclamations placing 50% tariffs on Canadian goods. Each one answers a different complaint. One about motor vehicles, one about alcohol, one about dairy. But the goods each proclamation actually taxes are a separate list, and those lists are far wider than the complaints. Between them, they reach products from wine to hockey sticks to cement. A few things are exempt, including energy, fish, and critical minerals. The tariffs take effect on the 19th of August, 30 days after signing, and they apply to goods that the North American Trade Agreement normally covers. The legal basis is a provision called Section 338. It comes from the Tariff Act of 1930, one of the oldest trade laws still on the books. Section 338 lets a president add duties of up to 50% on any country he determines is discriminating against American commerce. And the wording matters. The law only requires that the president find as a fact that discrimination exists. No investigation is required. The provision has been on the books since 1930. Until Monday, no president had ever used it to actually impose a tariff. To see why a tariff like this hits Canadian and American factories so hard, follow a single piston. It is cast in one country, machined in another, sent north for assembly with its rings and rods, shipped to yet another plant, and finally dropped into an engine that crosses the border one more time to be fitted into a car. That is 6 international crossings for a single component. That is normal. Canada's Prime Minister says the average car part crosses the Canada-US border about 6 times before final assembly, and industry estimates run as high as 8. Roughly 3/4 of everything Canada sells abroad goes to the United States. None of that was built for a world of 30-day notice. A factory line is an investment measured in decades. And on the 1st of July, the United States, Canada, and Mexico met for the trade agreement's scheduled 6-year review, where the United States declined to extend it. The agreement survives, but instead of being locked in for another 16 years, it now comes up for review every single year. A factory planner who had 16 years of certainty now has one. Now we get to the part that actually explains all of this. Under the American Constitution, tariffs belong to Congress. Article 1 is explicit. Congress shall have the power to lay and collect duties. It does not say the president, but over the last 90 years, Congress handed pieces of that power to the executive branch, one law at a time, and each one had a reason that seemed sensible on the day it passed. The oldest is from 1930. That is Section 338, the one being used this week, and it lets a president respond to countries that treat American goods unfairly. In 1962, Congress added a second law for national security. In 1974, it added 2 more in a single year, one for a sudden crisis in the country's finances and one for unfair trading practices abroad. And in 1977, it added a 5th for genuine national emergencies. 5 separate laws passed across 5 decades, and every one of them is still on the books today. Look at any one of them on its own, and it is defensible. A country does need to be able to respond quickly when something goes wrong, and a legislature of 535 people is not built for speed. But add them together and you get something nobody voted for as a whole. They are 5 different legal doors into the same room. And here is the part that matters most. Because these powers were handed over permanently, none of them expires on its own. A law that is never used never goes away. It just gathers dust, waiting. Which brings us back to February, and to the clearest demonstration of this you will ever get. The tariffs the president had imposed across dozens of countries were built on the 1977 emergency law. Importers sued. The case reached the Supreme Court, and in February, the court ruled against the government 6-3. Chief Justice Roberts wrote that the emergency law contains no reference to tariffs or duties, and that until now, no president had ever read it that way. The government lost the case, and the tariffs were switched off that same day. And on the same day, a different law was used, the 1974 law, for a sudden crisis in the country's finances, allowing a temporary extra charge on imports from every country at once. That one comes with a limit, a maximum of 15%, and a hard stop after 150 days, after which Congress has to vote. Those 150 days run out this Friday, the 24th of July. The new tariffs were signed on Monday the 20th under the law from 1930. Whatever the reasoning behind the timing, the structure made that handover available. When one authority runs out, another one is already there. There is a second loop running underneath, and it is worth seeing clearly because it is not one-sided. Section 338 requires that finding of discrimination. So where does the finding come from? From Canada's own tariffs, a 25% duty on certain American vehicles in place since April 2025, and the decision by almost every Canadian province to stop buying and selling American alcohol. But those Canadian measures were themselves a response to earlier American tariffs, which were themselves argued as an answer to conditions the American side considered unfair. Trace it back far enough, and there is no clean first move, which is exactly what makes this a loop rather than a line. Each side's defensive step becomes the legal trigger for the other side's next one. Ontario's premier has called for matching any new tariffs dollar for dollar. Canada's prime minister says his government believes in free and fair trade and is ready to negotiate. Both of those things are true at once, and that is the point. Inside this structure, retaliating and negotiating are not opposites. They are both rational and both feed the same loop. So what would a system look like that doesn't work this way? 3 redesigns are worth putting side by side, and none of them is free. The first one is already sitting in American law. Look again at that 1974 law, the one used in February. Alone among the 5, it has a fuse. The tariffs it allows are capped at 15%. They expire automatically after 150 days, and to continue them, Congress has to act. The power goes back to its owner unless somebody deliberately renews it, and you can watch that design working. That fuse burns out this week, which is why the question of what comes next arose this month at all. The honest cost is real. 150 days of tariffs still happen, and a 15% ceiling gives a negotiator less to push with because the other side knows exactly how high it can go and exactly when it ends. A fuse slows the power down. It does not stop it, but it is the only one of the 5 that hands the power back by itself. The second redesign is to remove the shelf entirely. That is roughly what the European Union did, though not on purpose. In the EU, trade policy is not a national power at all. It belongs to the Union. The European Commission negotiates, but agreements need approval from the member governments and from the European Parliament, and the EU's court enforces the result. And European law sits above the law of any single member country. So a national government cannot cancel a trade agreement with a decision of its own because there is no national door for it to reach for. The cost is exactly what it sounds like. It is slow because 27 governments have to agree, and an individual country gives up the ability to defend itself quickly, including in the cases where moving fast would have been the right call. That is a real handover of national control. The third redesign is the most direct. Take the shelf apart. One narrow version already exists as a bill. It was introduced in 2025 by Democratic members of the House Ways and Means Committee, and it would strike Section 338 from the law entirely on the grounds that a power from 1930 that no president had used in 90 years should not remain available. It has not passed. Proposals to put time limits on handed over powers have come from both parties over the years, and none of those has passed either. The broader version is a design principle rather than a single bill. Give every one of these handed over powers an expiry date, not a review and not a report. The power would simply switch itself off so that keeping it alive requires the legislature to vote again, the way some war powers and security laws already work. The costs here are real too. A legislature that must vote is slower than a crisis, and sometimes a country genuinely needs to move in days, and there is an uncomfortable pattern in how sunsets actually behave. Renewals tend to become routine, and the fuse quietly turns into a formality. So let us go back to the wall. The court did its job. It read one law, decided that law did not authorize what was being done with it, and said so. That ruling stands, and the tariffs it struck down are gone. What the ruling could not do is reduce the total amount of power on the other side of the wall, because a court can only answer the question in front of it. Does this particular law permit this particular action? When other laws are available, a ruling of no does not stop the action. It just sends it to a different door. The shelf belongs to Congress. It was built by Congress, one reasonable decision at a time, across dozens of administrations of both parties. It is the only body that can take it apart, and it has never had a deadline forcing it to look. 3 doors on that wall are still shut. None of them is locked.